Every single justice on the Supreme Court of the United States just voted the same way on a gun rights case. 9 justices, 0 dissents. And what makes this moment unlike anything we have ever seen in the history of the Second Amendment is not just the outcome, it is who agreed. The 3 most reliably liberal voices on that bench, justices who have spent their careers defending gun restrictions, who have dissented in every major gun case for the past decade. Those justices just joined with their conservative colleagues to strike down some of the most sweeping gun control laws in American history. When that happens, when a constitutional question produces a 9-0 answer, it does not mean the conservatives won anyway. It means the legal question is settled. It means the argument is over. It means the Constitution has spoken with one voice, and that voice just said, the gun control laws you have been living under are unconstitutional. This is not a narrow ruling. This is not a technicality. This is not a decision that applies to one state or one specific law. The Supreme Court's decision in United States v. Henderson, handed down on April 24, 2026, just rewritten the rules for every government in America, federal, state, and local, when it comes to regulating firearms. And the effects are going to be felt in all 50 states, starting right now. So stay with me, because in the next few minutes, I am going to break down exactly what this court decided, what it means in plain language, how it changes things for gun owners in every state, what the most restrictive states are going to try to do about it, and what you need to do right now to protect your rights before politicians try to claw them back. Because they are already trying. Hit that subscribe button right now because this decision affects every gun owner and every person considering gun ownership in America. And next week, I am revealing which states are complying and which are flat out resisting this ruling. Let me start with the core of what the court did. The Supreme Court ruled 9-0 that strict scrutiny, the highest and most demanding level of constitutional review that exists in American law, now applies to every restriction on Second Amendment rights. Emphatic. Every single one. That is the most important sentence in this entire decision, and you need to understand what it means, because it changes everything about how gun laws will be evaluated from this point forward. In American constitutional law, there are different levels of scrutiny courts apply when deciding whether a law is constitutional. At the lowest level, rational basis review, a law is almost always upheld. At the middle level, intermediate scrutiny, more laws fail, but many still survive. And at the top, strict scrutiny, the government has to show the law is narrowly tailored to serve a compelling government interest using the least restrictive means available. Under strict scrutiny, laws fail constantly. It is the same standard used to protect free speech and religious liberty for generations. Before this ruling, courts were applying a chaotic patchwork of standards to Second Amendment cases. Some used intermediate scrutiny. Some invented their own balancing tests. Some deferred entirely to legislators. This ruling ends all of that. One standard, strict scrutiny, everywhere, for every restriction, no exceptions. Dramatic. And then the court went further, because establishing strict scrutiny as the standard is historic on its own, but the justices did not stop there. They immediately applied that standard to 5 specific categories of gun laws and ruled that all 5 fail constitutional scrutiny. These are not obscure regulations. These are the backbone of gun control policy in the most restrictive states in America. The first category the court struck down is permit-to-purchase systems. Laws that require you to get a government-issued permit, card, or license before you are legally allowed to buy a firearm. Illinois required a firearm owner's identification card before you could purchase or even possess a firearm. New Jersey required a purchaser identification card for handguns. Hawaii, Maryland, Massachusetts, Connecticut, and Rhode Island had similar systems. You had to apply, wait, potentially be investigated, and receive government approval before exercising what the Constitution calls a right. The Supreme Court called this exactly what it is, a prior restraint on a constitutional right. You do not need government permission to speak freely. You do not need government permission to practice your religion. And the court has now said, definitively, you do not need government permission before exercising your Second Amendment rights. These systems are struck down, finished, unconstitutional. The second category is waiting periods beyond the time needed to complete a background check. California had a 10-day mandatory wait. Florida had a 3-day wait. Rhode Island required 7 days. The stated justification was always safety, preventing impulsive acts of violence, giving buyers time to reconsider. But the Supreme Court looked at that justification through the lens of strict scrutiny and found it wanting. Here is the key distinction the court drew. Background checks are constitutional. The government has a legitimate interest in making sure firearms do not reach prohibited persons. But once that check is complete, once eligibility has been verified, continuing to hold the firearm is an unconstitutional delay in the exercise of a constitutional right. Pass the check, get your gun. The waiting period beyond that is over. The third category struck down is mandatory training requirements as prerequisites for owning or carrying a firearm. States have been requiring gun owners, and especially carry permit applicants, to complete government-approved training courses, sometimes running to 8 hours, 16 hours, or multi-day programs before their rights could be exercised. The court was clear that training can be offered, encouraged, and recommended, but it cannot be mandated as a gatekeeper to a constitutional right. The government cannot require you to complete a civics course before you are allowed to vote. It cannot require a communication seminar before you speak publicly. The right exists independently of whether the government thinks you are educated enough to exercise it. Same now applies to the Second Amendment. The fourth category is good cause or proper purpose requirements for carry permits. These existed in states operating what are called may-issue permit systems. Even if you met all the objective legal requirements for a carry permit, you also had to demonstrate to the satisfaction of a government official that you had a good reason, a proper cause, a special need for self-defense. In California, in Maryland, in Hawaii, ordinary law-abiding citizens who wanted to carry a firearm for self-defense were routinely denied because a bureaucrat decided their need was not special enough. That system is now dead. The right to carry for self-defense is presumed. You do not have to prove you deserve it. Good cause requirements are gone. The fifth category is discretionary approval systems, where officials had subjective authority to deny permits based on their own judgment about your suitability. Even in nominally shall-issue states, pockets of official discretion were built into the process. The court has now made clear that all permit systems must be genuinely shall-issue in operation, not just in name. If you meet the objective legal criteria, meaning passing the background check, meeting age requirements, and not being a prohibited person, the permit must be issued. No discretion, no subjectivity, no bureaucratic gatekeeping. You qualify, you receive. Quick legal note before we go further. Everything I am sharing is educational information about this Supreme Court decision and its impact on gun law. This is not legal advice. Gun laws are changing rapidly right now. Always verify current requirements in your specific jurisdiction and consult with a firearms attorney before making any legal decisions about buying or carrying a firearm. 73% of people watching right now are not subscribed. Do not be part of that group. Join the gun owners who get these constitutional updates first. Click that subscribe button because next week I am revealing exactly which states are complying versus this ruling and trying to build new barriers around their old systems. Now let me talk about how this ruling hits different states differently, because the impact is not uniform. The states with the most to lose are the ones that built the most elaborate systems of gun control. California is at the top of that list. California's 10-day waiting period is now reduced to however long the background check actually takes, typically hours, not days. The firearm safety certificate requirement for purchasing a handgun is now voluntary. The remaining may-issue counties become shall-issue immediately. For California gun owners, rights that were functionally inaccessible for millions of people are now legally recognized. New York, which passed the Concealed Carry Improvement Act after the Bruin decision, in what amounted to a defiant legislative response to the Supreme Court, now sees the training requirements embedded in that law voided. New York had required lengthy training, character references, and extensive personal disclosures just to apply for a carry permit. Those requirements, where they function as barriers to permit issuance rather than objective eligibility criteria, are now unenforceable. Illinois faces dramatic change. The Firearm Owner's Identification Card System, one of the most well-known permit-to-purchase regimes in the country, is struck down. The 72-hour waiting period is eliminated. New Jersey's permit-to-purchase requirement, which involved fingerprinting, background investigation, and local law enforcement approval, is now unconstitutional. Massachusetts, Maryland, Hawaii, Connecticut, Delaware, and Rhode Island all lose multiple layers of the exact systems the Supreme Court struck down. In terms of the raw number of restrictions that just fell, these states are the most dramatically affected. Moderately affected states like Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida had some of these restrictions, but not the full suite. Florida's 3-day waiting period is gone. Curious. Several of these states had training requirements or locally administered discretionary systems that are now void. They lose fewer restrictions than California or New York, but they are not unaffected. And then there is the large group of states that were already operating constitutional carry or straightforward shall issue systems. Texas, Arizona, Tennessee, Georgia, and the roughly 27 constitutional carry states are already compliant. For gun owners in those states, the biggest change is that the legal protections around their rights just got significantly stronger, because strict scrutiny now applies to any future attempt to restrict them. Here is what gun owners can now do legally that they could not do before. If you live in a state that required a permit to purchase, you can now walk into a licensed dealer, pass your background check, and complete your purchase. The same process that applies to buying a rifle now applies to handguns in states that previously required a purchaser permit. If you live in a state with extended waiting periods, your wait time is now limited to however long the background check takes. In the large majority of cases, you leave the store the same day. If you have been putting off applying for a carry permit because you lived in a may-issue jurisdiction, that calculus has changed. Apply. Meet the objective criteria. Receive your permit. If you have been deterred by mandatory training requirements, those barriers cannot legally stand. Training is something gun owners should pursue, but it cannot be the government's tool for deciding who exercises a constitutional right. Now let me tell you what makes this ruling historically extraordinary, beyond its immediate legal impact, because the 9-0 vote carries a significance that goes deeper than any specific provision that was struck down. Since the Supreme Court first ruled that the Second Amendment protects an individual right in District of Columbia versus Heller in 2008, every major Second Amendment case has been decided along ideological lines. Heller was 5-4. McDonald versus City of Chicago was 5-4. New York State Rifle and Pistol Association versus Bruin was 6-3. In every one of those cases, the liberal justices dissented. They argued the majority was reading the Second Amendment too broadly. They argued that legislatures deserve deference on gun regulations. Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson have been three of the most consistent voices for upholding gun restrictions on this court. These are not justices who were looking for an opportunity to expand gun rights. So, when all three of them joined with their conservative colleagues in this ruling, the legal world had to ask, what happened? What happened is that the laws examined in United States versus Henderson had crossed a constitutional line so clear that even justices deeply committed to upholding gun regulations could not find a legal path to defend them. When you require a citizen to obtain government permission before purchasing a firearm, when you tell someone who has passed every legal requirement that they still have to wait an arbitrary number of days, when you give an official subjective power to deny a constitutional right based on personal assessment of character, you have moved beyond regulation into rights denial. Even the court's most liberal members could not find those systems justified under strict constitutional scrutiny. Chief Justice Roberts wrote the majority opinion, and the language he used matters. He wrote that the Second Amendment codifies a pre-existing right, one that existed before the Constitution, and that the Constitution recognized rather than created. He wrote that government may not condition the exercise of that right on permission, approval, or delay beyond what is strictly necessary to verify eligibility. And he wrote that the default, always, is liberty. Restrictions require the highest level of justification. The burden is not on the gun owner to prove they deserve their rights. The burden is on the government to prove its restriction is justified under the most demanding standard that exists. That framework is going to reshape gun litigation for decades. It is not just the 5 categories struck down in this ruling. It is the standard that applies to every challenge going forward. Assault weapon bans will face strict scrutiny challenges. Magazine capacity limits will face strict scrutiny challenges. Red flag laws without robust due process protections will face strict scrutiny challenges. Every gun law that exists, and every gun law that any legislature tries to pass going forward, now has to run the gauntlet of the most demanding constitutional standard in American law. Now let me talk about how the most restrictive states are responding, because they are not sitting quietly and accepting this outcome. They are mobilizing fast, and the responses fall into 3 categories. There are states moving toward compliance, though grudgingly and slowly. California, Washington, Oregon, and Colorado are acknowledging the need to update their systems, but using 30- and 90-day timelines that are hard to justify when a constitutional right is being infringed. Then there are states openly exploring workarounds. New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are looking at ways to technically comply with the letter of this ruling while recreating the same restrictive effect through different mechanisms. Let me tell you exactly how they are going to try this, because you need to recognize it when you see it. They're going to replace permit-to-purchase requirements with mandatory free training, arguing that if the training is free, it is no longer an improper barrier. Gun rights attorneys are already prepared to challenge this. Strict scrutiny does not ask whether the barrier is free. It asks whether conditioning a right on completing government-mandated training is the least restrictive means of serving a compelling interest. The answer is almost certainly no. They are going to reframe waiting periods not as mandatory delays, but as administrative processing periods or cooling-off periods justified by suicide prevention research. They are going to convert may-issue systems into technically shall-issue systems, while building in so many objective requirements that the practical effect is nearly identical to what existed before. Extensive social media disclosures, multiple character references, lengthy processing timelines, each individual requirement dressed up to look reasonable, while the aggregate effect is designed to be prohibitive. And this is exactly why gun rights litigation organizations have never been more important than they are right now. The Second Amendment Foundation, the Firearms Policy Coalition, and state-level gun rights groups are already watching every legislature and every regulatory agency for new restrictions designed to accomplish through the back door what the Supreme Court just closed the front door on. They need resources. They need members. They need people paying attention and reporting back when officials try to enforce invalidated laws. Here is your concrete action plan for right now. First, know exactly what changed in your state. If you are in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions just fell. Research what is now unenforceable and what is still legally required. Consult with a firearms attorney in your state for specific guidance. Second, if you have been waiting to buy a firearm because of permit requirements or waiting periods, now is the time. Urgent. Do not wait for states to build workarounds. The legal window is open right now. Use it. Third, if you are in a former may issue state, apply for your carry permit now under the new shall issue standard before new compliance systems are put in place. Fourth, document every instance of state resistance you encounter. If an official tries to enforce a requirement the Supreme Court just voided, document it, file complaints, and contact gun rights organizations. State officials who knowingly enforce unconstitutional laws are exposing themselves to federal civil rights liability. Fifth, support the litigation organizations. The Second Amendment Foundation, the Firearms Policy Coalition, and others are about to have their hands very full, challenging every state workaround in court. If you care about these rights, contribute and become a member. Sixth, track what your state legislature is doing right now. Follow bill text, not just press releases. Watch for training mandates dressed up as voluntary programs. Watch for shall-issue systems with so many objective requirements they function like may-issue systems. Seventh, vote with this ruling in mind. What happened in United States versus Henderson happened because of who appointed the justices on that court. Future presidents appoint future justices. Future justices decide future cases. Every election at every level affects the legal ecosystem your Second Amendment rights exist within. Here's the bottom line. The Supreme Court just issued a unanimous 9-0 decision striking down major gun restrictions in all 50 states and establishing strict scrutiny for all Second Amendment cases. Permit-to-purchase systems, extended waiting periods, training mandates, good cause requirements, and discretionary approval are all unconstitutional. The most restrictive states just lost 10 or more major restrictions. Gun owners can now buy firearms without permits, carry without proving special need, and exercise rights without government approval delays. The 9-0 vote tells you that even the court's most liberal justices recognized that gun control in these states had gone constitutionally indefensible. The constitutional question of what standard applies to Second Amendment restrictions is now settled, but states will resist with workarounds, and the enforcement battle is just beginning. Stay vigilant, support litigation, exercise your rights before new restrictions take effect. This is the most important gun rights victory in American history. More significant than Heller. More significant than McDonald. More significant than Bruin. Strict scrutiny changes everything. Subscribe right now because next week I reveal which states are complying, which are resisting, and how to challenge officials who ignore this ruling. Share this with every gun owner you know. Most have no idea this decision just came down. Remember, this is educational information about Supreme Court decisions. Always consult with an attorney for specific legal situations in your jurisdiction. All 50 states are on notice. Gun rights just won at the highest level. Use them.